Can you believe there's a verdict in the Alex Murdaugh trial? It's a very high profile case. The jurors came back with a guilty verdict that he murdered his wife and son. And we're going to talk about what that means and what it teaches us. Trials have been going on for centuries and being judged by our peers known today as a jury, where random citizens are chosen to judge an accused fate. The idea is to separate the power that the state has. And that is because the state has the burden of proof. So to set us up, let's watch a clip from the closing argument that the solicitor for the defense made, and then we'll get into it.
Proved by clear and convincing evidence, and that's an intermediate level of proof. And so it's not just tilt the scales ever so slightly in the favor of the party that prevails, but you have to get sort of 3/4 of the way there. But now, proof beyond a reasonable doubt is the highest standard of proof the law recognizes, and it is you have to tilt the scales all the way to one side in order for the state to meet their burden. Now, a little bit about the verdict. You will have an option of guilty or not guilty. My friend Dick Harpootlian over here he travels a lot. He's been to a lot of countries, and he frequently, he recently returned from Scotland, where he attended a jury trial in Scotland. And he tells me it's much like this, except the lawyers wear a wig, and I might benefit from something like that. But in Scotland, it runs about the same until it gets time to the verdict in the criminal case. And the jury in Scotland, where we derive our laws from, and they are given 3 options. One option is guilty. Second option is not guilty. And the third option is not proven. Not proven. Now here in America, we have combined the verdict of innocent and not proven into one of not guilty. And so when you go to render your verdict, if it's a verdict of not guilty, it's either you concluded that the defendant is innocent of the charges, or that the government has not met their burden of proof, their heavy burden of proof beyond a reasonable doubt. Now, and one of the reasons that defendants are presumed innocent and the government has such a high burden is because in criminal cases, the defendant really doesn't have the ability, doesn't have the resources, doesn't have the lawful authority to execute search warrants, subpoena documents, to prove his or her innocence. And so a defendant cannot secure a crime scene, cannot lift a crime scene for fingerprints, shoe-wear impressions, cannot secure telephones and get electronic data in the course of an investigation.
So I kind of wondered why the defense solicitor was giving these arguments to the jury, because I thought to myself, well, maybe he kind of knows that the jury thinks he's guilty already. So I did some digging, and I found out that the first Prime Minister of Scotland actually wants to abolish this third choice that the jurors have, not proven, doesn't actually mean that the person is not guilty. It has the same result, but what it actually means is that the person is acquitted, but the jury thought that the defendant was guilty, but they didn't think that the prosecutor proved their case. This will stay with the defendant, which we'll talk about a bit later. In the Murdaugh case, the jurors have already been speaking out. I did a video on the risks of character evidence being introduced to a hearing or a criminal trial. If you want to check that out, all I ask is that you please subscribe. It helps our channel to grow. But for now, I'd like you to listen to one of the jurors, as it's quite interesting what he said he would personally have liked to see.
At prosecution, defense, and the witness on the stand throughout the entire trial. Being able to make eye contact with somebody is, I don't know why, but I'll make eye contact with people a lot, especially during the trial. And it was something that I noticed that he very rarely ever made eye contact with me. And I don't know if it was on purpose or if it was just because I always sat all the way on the end. You know, I was kind of away from the rest of the jury once we lost a few alternates.
Wow, so what'd you think of that? This is exactly what I tell my clients. When they're given testimony, they must look at the fact finder when they're answering the question. And the reason you do this is because the fact finder is the person that's going to be deciding whether or not you're telling the truth. I have actually had a judge in a case tell the person on the stand that they must look at him when they're given an answer. Don't look around the court, look at me. That's what the judge said. So I thought that was quite interesting that this jurist noticed that. Another point I'd like to make is when you take the stand, you will have to make an oath to say you are going to tell the truth. I've done a video on this, which you can watch in my playlist, Going to Court. If you don't take the stand to testify on your own behalf, the judge gives instructions to not hold that against you. And a party for either side should never put someone on the stand if they know that that person will tell a lie. And the judge will give instructions that if you, the jurist, thinks the witness is lying, you can disregard some or all of their testimony. If, for example, the defendant is telling the truth, but the prosecution has given circumstantial evidence that does not support the testimony you just heard to believe to be true, then you can take the testimony over the questionable evidence. And if this is the situation, you should give a not guilty verdict. And you do this to protect a miscarriage of justice. So if the evidence presented by the prosecution left you with questions that caused you to be unsure, then you must give the benefit of doubt to the defendant. That is the way you should weight the evidence. If you are not sure of it, the defendant gets the benefit of the doubt. And this is the same in the UK. So one of the other concerns was that the jurors didn't take very long to come back with a decision of guilty. And I found this great clip from Viva and Barnes. I think Robert Barnes explains it really well, and maybe why this could be quite concerning.
Room for a reasonable doubt? All things considered, I mean, geez, if this guy's not the murderer, well, somebody's going to get off scot-free, luckily. But what's your take on the entire thing? I mean, I think I know, but what's your take?
So, I mean, on the, I'm not surprised by the jury verdict. My view was, and my view generally is, that jurors make up their mind before they sit down. They don't often realize that, but, you know, having done lots of not only jury trials, but mock juries, which really allow you to explore this, to explore what biases they may have beforehand and then before they hear the facts and so forth, you see this in live time. Given how short they deliberated.
3 hours, no questions for the judge.
And basically they admitted that they had made their decision within like 45 minutes, from at least what some jurors have said afterwards. Quite frankly, that's not a jury that did their job. So when you have a double murder trial where someone's life is on the line in terms of the defendant, and you have weeks and weeks of trial testimony, when you rush to a verdict, you didn't do your job. So every one of those jurors should be embarrassed. They should be ashamed. They should be humiliated because you didn't uphold your oath. You violated your oath to those jurors. I say this even in cases where I think somebody's guilty. Because if you do your job, you should take days to go. And what you should, I had a great conscientious jury in a case where they convicted my client. It took them longer to deliberate than the trial took. Why? Because the foreman, who I picked because he said.
Well, I couldn't agree more. And Viva and Barnes are great. I've left their links in the description area, so you can follow them on YouTube or Rumble. If you haven't heard of Rumble, it's a kind of a new platform. There's lots of new people going on there. But this is a good time to tell you, when I was working for the local government, I would take civil claims to court on behalf of for them. And when I was working for a district council, I would work in the magistrates court doing appeals, representing the council, the district for appeals. The reason we have a higher burden of proof is because the state has all the power. So the judges like us to rely on more direct evidence than indirect evidence. And the reason for this is because we are much more powerful than most people, and they don't have the resources to maybe, have a good solicitor or representation. So you want to make sure your case is airtight. What I didn't like about this case in the Murdaugh trial was at the end, the state almost took a victory lap. And I thought their evidence wasn't that great. I may not be popular with a lot of people, but there was a lot of people that certainly thought the same. And because of that, I think they were this close to having a hung jury. And I think that's why I think they shouldn't have done such a victory lap. So why does all this matter? Because one day you or someone you love could be before the courts. And once you're in that position of defending yourself, it's a completely different feeling. You lose a lot of your control. And I did think the judge was a bit biased in this case, though I think he had good reason to be. He was fair, but I do think he was biased in the sense that Alex Murdaugh was a solicitor that argued before him for many, many years, and he had a lot of respect for him. So he was really surprised that his life had become so horrific, really. And when he gave Alex an opportunity to say something, and Mr. Murdaugh said, I didn't hurt my wife. I would never hurt my wife and son. The judge said, maybe it wasn't you. Maybe it was the monster you became when you took drugs. The judge was really powerful with that statement, and that really hit me hard, that he did have this expectation to be better, because his father, Alex Murdaugh's father, and his grandfather were solicitors for that county, for that district, just like we have county solicitors here. So they had the power of the legal system for over 100 years. And I think because of that, there should be an expectation that he knows better. And so I'm not sure he's guilty of these murders, but we'll see what happens. People say there could be appeals. I don't know. But it's very disappointing either way. We've got 2 victims, and it's very sad. And if you watch the Netflix series, you're going to see that there's this family is being I can't even speak, suspected of a lot of criminal activity. I'll leave it there, and you can find out for yourself. So just before ending, I said I would tell you why the Prime Minister of Scotland wants to put a bill across to abolish the third not proven verdict. And that's because what happens with a defendant is they never feel vindicated. Everyone still thinks they're guilty, and the courts don't keep a record of that, but the police do. So it could come up on a employment check. The other thing is victims don't feel vindicated. It might feel nice that someone believes you, because that's what not proven means. You believe the accused to be guilty, but you don't think the state met their burden of proof. And the reason that victims don't feel vindicated is because they didn't get justice. So there's a fine line between that, and the first Prime Minister of Scotland really wants to change that, because they feel that, well, I think there's like 60% of people in Scotland that want this to be abolished, because they feel that it doesn't really give, you don't really have to make a decision with a not proven. It gives too much of an opportunity for people to just tune out and not make a decision one way or the other. So what we've learned is that both sides have learned a lot from this trial. I think it will definitely go down in the history books, right up there with OJ. There's going to be people that think he's guilty and people that think the state didn't prove their case. Well, I hope you found today's video interesting, and information is power. Why not subscribe and watch more of our videos? If you need legal help, contact legal-minded friends.